Hello, everyone, and welcome to Motions to Amend End-to-End, part of Virtual Patent Gateway's PTAB Practitioner series, hosted by Virtual Patent Gateway founder Ashley Chung. Virtual Patent Gateway, VPG, was founded in January 2020, right before the pandemic, and Ashley has a passion for supporting PTAB practitioners and is committed to developing a growth mindset within VPG. Joining us today are Alyssa Holtslander and Kevin McNish. Alyssa is a Senior Patent Counsel at Unified Patents and prepares and litigates post-grant proceedings before the PTAB and appeals before the Federal Circuit for Unified Patents. She has over 10 years of experience in intellectual property services. A registered patent attorney, Kevin McNish represents clients in inter partes reviews, post-grant reviews, ex parte reexaminations, and other proceedings in the United States Patent and Trademark Office. He is currently the managing member of McNish PLLC. This webinar will be recorded for future use and has been approved for Virginia CLE for 1 hour. There will be a short Q&A at the end of the presentation. And with that, I'll hand things over to Alyssa.
Thank you very much. I appreciate the introduction, and thank you to those who have joined us to talk about motions to amend today. We're going to talk about some of the rules and regulations that have to deal with motions to amend. We'll also talk about statistics and some things that happen after the board decides on motions to amend. And then finally, just give some practice tips for everyone to follow. If you want to move down to the next slide, we'll start on the law and procedure. So first, when we look to the requirements for the motion to amend, patent owners need to look at these very carefully because the board can take a very strict reading of making sure a patent owner has followed the requirements. When filing a motion to amend, you must show support for all claim elements in the original patent application for your proposed substitute claims. And so what this means is you can't just cite to support in the patent, the published patent, for your new claim elements. You need to actually go back to the patent application and cite support for all claim elements, including the ones that you're adding. And then if you want to get priority back to potentially a foreign document or some other type of application, you also need to cite support in that priority document. In addition, you need to include a claim listing that shows all the proposed substitute claims and shows the changes with respect to the original claims. And just a note, whenever you do these claim listings, your new substitute claims should come after the original ones. Sometimes I've seen patent owners confused and they'll do substitute claim 1, which is meant to amend original claim 1. But for example, if you have 12 original claims, your first substitute claim would be claim 13. And then after the motion to amend meets the statutory requirements, then the petitioner has the burden to show that the substitute claims are unpatentable by a preponderance of the evidence. If you want to go on to the next slide, we'll talk about what some of those statutory and regulatory requirements are. And again, I want to note that as the patent owner, you really need to look at these requirements and double check your motion to amend to make sure you have followed all of the rules that are required. So first off, they require a reasonable number of substitute claims. And typically that means you can have one substitute claim per original claim, unless you have a reason why you may need more. In my cases, I personally haven't had the board allow for more than one substitute claim. Kevin, I don't know, have you had that in any of your cases?
Not in my cases, but I have seen instances where the board has allowed a small number where there's still more than one claim, substitute claim per original claim. Usually though, that's kind of peer dependency. So essentially you have, it's almost like presenting backup positions within a single motion to amend. Even then, though, you have to show a demonstrated need for multiple claims for one dependent claim. That's about the only exception, and rule of thumb, you really do need to try to keep it 1-to-1, one substitute claim per original claim to be amended.
Yeah, that's what I've seen as well. So the next requirement is that your amendments need to be responsive to a ground of unpatentability, which means that you need to be amending to overcome the prior art that was in the original petition. Now, this doesn't mean that your amendments are limited to that. You could also amend the claims to get rid of 112 issues or 101 issues that you're concerned about. But you do have to show that you have amendments that are in the claims responsive to the grounds in the petition, and at least one of the grounds in the petition, I would say. In addition, you cannot enlarge the scope of the claims. So if for any reason you are crossing out any words in the claims when you're doing a substitute amendment and not just adding words in, you need to be extremely careful that you are not somehow enlarging the scope. Even if you narrow the scope in one way, you cannot enlarge the scope in a different way. It typically, to be the most careful, you should just be adding on additional limitations. However, like I said before, if there are 112 issues, if there are 101 issues that you need to address, sometimes you may need to cross the term out to write it a different way. But in those cases, you should be really double checking your claims to make sure that it's not somehow enlarging the scope of the claims. And then finally, you cannot add new matter. And this goes back to the requirement that you need to show support for all the limitations you're adding, as well as the original limitations in the claim in the original application as filed and in any priority documents. Move to the next slide. So now, once the patent owner has filed a motion to amend, then it goes to the petitioner to oppose that motion to amend, and then they can have grounds for unpatentability. Unlike the petition, where you're limited to section 102 and 103 grounds, you are actually allowed to raise 101 and 112 grounds in your opposition to the motion to amend. And so that's important to think about. And if there are 101 and 112 issues in the corresponding litigation that you weren't able to address in your petition, it may be a time to address it now. However, if the patent owner is trying to amend the claims to fix those issues, you need to take the time to really look at the claims and see if there's any other issues to address. And then I also want to note, for your 102 and 103 rejections, you have a limited amount of time to file your opposition. So you need to look at the claims early and see if you're going to need new prior art, and get those prior art searches started very quickly. Sometimes it may be a minor amendment that's added. Sometimes the patent owner wants to make their claims really narrow just because they want the patent to get through. And that prior art search may be really important. Go ahead to the next slide. So related to this case, Hunting Titan, it's provided that the board may, in certain rare circumstances, raise a ground of unpatentability that a petitioner did not advance or insufficiently developed against substitute claims proposed in a motion to amend. And here, kind of those rare circumstances are if a petitioner has ceased to participate, or the ground is so readily identifiable that the board should take it up basically in the interests of the integrity of the patent system. That is a very, very limited proposition though, and that's not going to happen in a lot of cases. And Kevin, have you had any cases of your own where this has occurred?
Not of my own. I think the only time I saw it in the cases I looked through was a very, very glaring antecedent basis issue that the patent owner, for some reason, didn't correct in its motion to amend. And it produced an indefiniteness issue. And, the patent owner had notice of it, I think via the preliminary guidance, if I'm not mistaken. So it's, it was something where I think the petitioner was no longer participating at that point. And patent owner ultimately lost the motion to amend.
Yeah, so as a petitioner, you should not take this as the idea that the board will correct your mistakes that you make in your grounds. It's a very limited circumstance that the board will make these corrections and add their own ground or reason for rejecting the claims. So the PTAB did issue a final rule December 21st of 2020 to kind of put some of the case law, the presidential cases they had into one document for people to look at. And this clarifies that the patent owner bears the burden of showing that the motion to amend complies with the statutory and regulatory requirements. But then the petitioner, once those requirements are met, the petitioner does bear the burden of showing the unpatentability of the substitute claims proposed in the motion to amend. And here, this is similar to what the Hunting Titan case said. The final rule also states that the PTAB may grant or deny a motion to amend based on the interest of justice if supported by readily identifiable and persuasive evidence of the record. Again, they note if the petitioner has stopped participating, it's so easily identified and persuasive that they need to address it. And that also they want to make sure that the other side has an opportunity to address this issue. So the PTAB can rely on evidence suitable for a PTAB record, such as related proceedings before the PTAB or the USPTO and district court. But if they exercise this interest of justice discretion, they do need to give the parties an opportunity to respond. So if they're going to be adding a ground, it's not going to be first raised in the final written decision. They do need to give the parties an opportunity to address it. And then finally, the USPTO did state that it intended this final rule to be consistent with the current PTAB practice of motions to amend, reflected in some of the presidential decisions that we talked about earlier. Next slide. So they also have a motion to amend pilot program. And this pilot program can be very helpful to patent owners because it allows the patent owners to request preliminary guidance from the board about the likelihood that their motion to amend will succeed. It will typically take about 4 weeks to get this preliminary guidance. And then the patent owner has 4 ways they can respond. They can file a revised motion to amend. They can file a reply to the guidance. They could withdraw the motion to amend, or they could do nothing. Now, this can be very helpful to patent owners, especially when they have the burden of meeting the statutory and regulatory requirements, because the preliminary guidance could say, we didn't see where you provided support in the specification for your amendments or for certain limitations. And they then have an opportunity to correct that. They could also, state that they think the prior art that petitioner proposes in its opposition to the motion to amend would make the claims unpatentable. So the patent owner could decide to further narrow the claims, or if they think the board is wrong, they could file a reply to the guidance that specifies what that distinction really is. And go ahead to the next slide. So one thing to keep in mind with this pilot program, and I want to get your feedback, Kevin, too, after I mentioned the timing. Things are very tight. And so after a opposition to a motion to amend is filed, there is about a month for preliminary guidance. And then the patent owner, if they file a reply, is very quick, like 2 weeks after the preliminary guidance. So you need to be looking at that guidance and then filing your reply. Then after that, the petitioner gets a surreply, only has 6 weeks for that. And then you're right at the oral hearing. So these things are all kind of back to back to back. And I found, as being on the petitioner side in most of my cases, that you need to really be on top of, like I said, your prior art searching to do your opposition to the motion to amend, and really looking at these papers as soon as they are filed. So if there are problems with it, you can notify the board if you think something needs to be stricken or expunged, or you are addressing the issues as they come. And Kevin, have you seen that as well, the tight kind of timing when you're dealing with these?
I mean, you can just see from the schedule how tight it is. And, if you're a patent owner with the tightness of those deadlines, you have to start anticipating counter arguments, and you have to start anticipating what the petitioner might do in response to your motion to amend. If you've got, you have the prior art that's been asserted against you in the petition, you should distinguish over that. If there's prior art you've got in the invalidity contentions that could be raised at the patent office, other patents, other printed publications, take a look at those, because you need to be ready for them. They're the first place the petitioner is going to look, and you should expect to see them cited. If your inventors have publications that might be prior art, you need to take a look at those as well. That's, as a patent challenger, that's usually one of the first places I look for prior art is, has the inventor published something about this that's 102B or 102A1 art? Because, so know where the low-hanging fruit is if you're a patent owner, and, draft around it, and, anticipate reasonable counter arguments. Maybe you don't distinguish over prior art that the petitioner hasn't necessarily asserted, but you need a feel for where they're going. You should draft your claims that way as well.
Yes, I agree with all of that. And then going just to the next slide, it shows how really tight the timeline is if patent owner decides to file a revised motion to amend. Here, from the original motion to amend, the petitioner has 12 weeks to file an opposition. But if there's a revised motion to amend, the petitioner only gets 6 weeks to look for prior art, depending on how much the patent owner has changed the claims, and come up with new grounds potentially. Obviously, sometimes the patent owner, may not change the claims a lot in their revised motion to amend, but they may receive the preliminary guidance and just decide they want to really narrow the claims to get around any prior art that they know of. And here, the oral hearing gets pushed back to the 10-month mark too, and you're really just back to back on all of your filings. So you need to have that in mind and make sure you have the bandwidth to handle the responses and handle the time to review the documents when you get them.
Yeah, and on to that point, if you're a patent owner, the second you decide to file a motion to amend, which should be promptly after you get the institution decision, given the amount of work you need to put in, you need to make sure your expert's available too, especially if you're using an expert that is experienced and testifies in lots of cases, or maybe is subject to university academic calendar. because not having an expert lined up and having to rush through a declaration isn't fun for you, isn't fun for the expert, and isn't great for the client. It's a small practical logistical thing, but you need to keep it in mind. As much rush as there is on the petitioner, there's a pretty big rush on you too, and you need to be ready for it.
And one final thing I want to note, as the patent owner too, you may want to consider what counsel you want to have on your IPR. Sometimes counsel from the district court litigation is also counsel on the IPR, but if you start filing a motion to amend, then you may want to separate what counsel you're using, and make sure that you have different new people that aren't involved in the litigation handling your motion to amend.
Yeah, the last thing you want is a prosecution bar to show up. I've actually had document productions where in the production letter, it would say Kevin McNish does not get to see these documents, just in case he might amend the claims. So something to keep in mind if you're a petitioner as well when you're making those productions. So we've covered law and procedure, and we're going to turn to some trends and statistics, particularly involving this pilot program and some kind of interesting data that's come out of that. So, turning to motion to amend outcomes, historically it was believed that you were almost never going to see success in filing a motion to amend at the PTAB. And, in some of the early days, back when the board placed the burden of proving patentability on the patent owner, you can see that reflected in the results. This data from Docket Navigator shows typically you were not going to succeed in your motion to amend as a patent owner. Subsequent developments, including the Aqua Products case, which put the burden of proving unpatentability of the amended claims back on the petitioner, odds improved a little bit, and we actually start to see a slight increase in the grant rate over time. So what we have in this slide here is the success rate of a motion to amend being granted where at least one substitute claim is entered. Maybe not all of them are entered, maybe most of them are denied, but there's at least one entered, and presumably for a patent owner that represents some measure of success. You are presumably drafting litigation ready claims and getting something assertable out of the patent office, even if it's just one claim, is a win. And so those numbers are going up. You start to see in the early days that sort of single-digit percentage success rate, where conventional wisdom was the Patent Trial and Appeal Board just isn't going to grant motions to amend, it isn't worth even trying, to something where the numbers are looking a little bit better, or a little more favorable to patent owners, close to about 24% in 2020, and we're seeing some continuation of that trend year to date in 2021. The grant rate for all substitute claims being entered, still not super high. I think one thing you might notice is the zero complete success rate in some of the early years of the PTAB. But this is where every substitute claim is entered, and we're starting to see numbers creep up again. Part of that's favorable allocation of the burden of proof for patent owners, as in Aqua Products. The preliminary guidance program may be contributing to that as well. But we're starting to see, again, the grant rate for all substitute claims creep up again to a little over 10% in 2020. So, just in broad strokes, the climate is more favorable than it has ever been for patent owners to file motions to amend. That said, still not super favorable. You're looking at a little under 25% success rate for at least one claim, and just a little over 10% for all substitute claims being entered. So what we did is essentially pulled every case I could find in PTAB proceedings that had preliminary guidance in them, used Docket Navigator to find those. And I put together a big Excel spreadsheet, hand-coded decisions and their guidance documents and their corresponding final written decisions. And, we're able to generate data from that. I will say there's a little bit of noise in these proceedings. Oftentimes you will see motions to amend address the same issue across related patents. so that essentially you have one issue dominating multiple proceedings, and that gets counted, more than one time. I left those in because I thought it would be a good aggregate reflection of what's going on, and that multiple proceeding, multiple patents, single issue scenario comes up. It's a recurring issue when related patents are asserted, when related patents are challenged at the Patent Trial and Appeal Board. It won't shock people to learn that patent owners are usually seeking preliminary guidance for their motions to amend. I think the most recent study I saw, this is a Perkins-Coie study, was something like somewhere north of 70%. So it has proven popular with patent owners. So what this focuses more on is what is happening when the patent owner seeks preliminary guidance. First, took a look at the preliminary guidance as pertains to the statutory and regulatory responses requirements. And so those are the things set forth in lector sonnets and by regulation, reasonable number of substitute claims, responsive to a ground of patentability, not broadening the claims, no new matter. That's the first set of 4 hurdles that the patent owner has to overcome. More than half of the proposed motions to amend, the opening motions to amend, for which preliminary guidance was sought, had at least one statutory or regulatory problem under those 4 hurdles. A little bit under half, 41 of the 97, did not have any of those problems.
Yeah, I think that really just shows how important it is as patent owner to really go through each of those statutory requirements to make sure that you've met them and double check your work, because the board is definitely very particular about making sure those are all met.
Absolutely. And on that note, the one that is met least often, in other words, the issue that poses the biggest problem for patent owners, has been new matter. So most of the time the patent owner is getting unfavorable guidance. It's usually because of a new matter issue. I have a couple theories for that. The first one being that the patent owner is taking its first shot to be a little aggressive about what new matter is, especially because it gets to file a revised motion to amend. The second is that it's actually a relatively easier issue for petitioners to litigate, because instead of having to read a bunch of prior art, instead of having to develop obviousness combinations, you can just look at what's in the original specification and any parent applications. Alyssa, what's your perspective on that?
So I agree with what you said. I also think that there have been patent owners that cite to the wrong document. Either they cite to the patent instead of the application, or they forget that they need to cite to their priority document, and they don't show the support in those documents that they're looking after. So I think it can be a combination of those things.
Yeah, and as a patent owner, the new matter issue is a really important one to get right at the PTAB. It's an issue that, as a sort of subset of written description, gets reviewed under the deferential substantial evidence standard at the Federal Circuit. So if you lose on the new matter issue at the PTAB in the final written decision, good chance you're losing it at the Federal Circuit too. So some of the other prongs come up a little bit less often. Not responsive in particular comes up relatively rarely. Usually that's something where the patent owner has done a whole-scale revision of their claims without really explaining why the whole-scale revision overcomes an unpatentability ground of the petition. And in a surprising number of motions to amend, I'd say maybe 20–25% of the ones I looked at, you actually had patent owners attempting to amend unchallenged claims, usually something that depended from an independent claim that was challenged. That's not something you can do. The Patent Trial and Appeal Board won't look at it and won't address the unchallenged claims. Your amendment has to address claims that have actually been instituted on. So turning from statutory and regulatory preliminary guidance, now let's turn to conditions of patentability. And here you see in the vast majority of preliminary guidance, patent owners are getting unfavorable guidance as to the patentability of their claims. Now, in some given the number of new matter issues that comes up, that's maybe not all that surprising, because if you've got a new matter problem, by default, you also have a written description issue. But just as a practical matter, this you can imagine why this might happen, in that you're ultimately working from claims that the board has already thought there was a reasonable likelihood were unpatentable. Now you're amending those claims, and short of some pretty serious amendments, you're likely again to have difficulty changing the board's mind on that issue, especially if the petitioner has brought new prior art to address anything that you've amended. Alyssa, how have you seen differences between how the board treats amended claims when there's new prior art or versus just prior art that was asserted in the petition, or is there a difference?
So I think that, I've had cases both ways where, we've filed an opposition based on grounds that were in the original petition. And then we've also done backup grounds with additional art. And from what I've seen in the preliminary guidance, the board just addresses what they need to. So if they think, one of the most broad grounds addresses the claims, then they may not get into the new references that you added if they didn't think they were necessary. They may just look at, whatever first ground they see as being successful, and then not provide guidance for the rest.
Mm-hmm. Yeah, and it's sort of just consistent with the board's sort of judicial economy, address what we need to, and because we're very busy, we have a lot to do, especially in the short timeframes with the motion to amend. All right, so turning to the next slide, we have sort of an overall favorability pie chart here, and the vast majority of the time, patent owners are getting unfavorable guidance. Unfavorable as to at least one claim. There's an issue with a statutory or regulatory requirement. There's an issue with patentability, or possibly both. So something is going, favorable guidance being defined here as the motion to amend likely satisfies all statutory and regulatory requirements, and all substitute claims are likely not unpatentable. It's tough. It's tough for a patent owner in a motion to amend. And although I will say, I think this could also be a product of patent owners willing to take a little bit of risk with their opening motion to amend, knowing that they've got a revised motion to amend and potentially an ex parte re-exam after the final written decision available to them. So you've got a couple chances. You may as well swing for the fences and get the best claims that you want as a patent owner with your first shot.
Yeah, and I just want to note with this, it's really important as the patent owner to read the preliminary guidance very carefully, because I've had, one case where we filed an opposition, the board gave, unfavorable preliminary guidance that they didn't think it would be patentable. But in addition to the issues we found, they also noted a couple other 112 issues. And when the patent owner filed their revised motion to amend, they didn't address those 112 issues that the board noted on their own. So then obviously, whenever we filed our opposition to the revised motion to amend, we included those. So it's just, even if the petitioner didn't necessarily raise it in their opposition, read the guidance really carefully to see if there's anything else that the board is telling you that there's an issue with.
Yes, yeah, and as a patent owner, you don't get 312 amendments, you don't get examiner amendments to correct any typos or any other sort of boo-boos you made in your motion to amend. You have to get it right, because the board's not going to fix it for you. So in cases where the board has given favorable preliminary guidance, those rare circumstances, unsurprisingly, that has generally correlated with success in the motion to amend for the patent owner. But patent owners are reacting to unfavorable guidance typically by filing revised motions to amend. It's in a relatively rare scenario where they decide to bulldoze ahead and say, nope, we're actually going to stick with the original claims. And but more likely than not, they usually will file a revised motion to amend. So what's happening when patent owners are filing those revised motions to amend? You're still seeing some relatively low grant rates in the entire grand scheme of things, but this includes things like requests for adverse judgment, where the patent owner has said, all right, look, if we didn't get these claims, we're not getting anything, so we're out. You've seen some settlements after the revised motion to amend. We don't have precisely what's happened in those cases, but it may be because the patent owner ultimately narrowed the claims in a way that the petitioner did not infringe, and the patent owner said, yeah, we don't really want to mess with this petitioner anymore. And you've also seen a lot of revised motions denied. So sort of the more interesting denominator is if you just go to dispositions on the merits, you start seeing about 18.6% of motions to amend granted on the merits, and for at least one claim. And for substitute claims, you're getting all substitute claims in about 5 out of 43 times, or about 11.6%. That's roughly in line with the overall grant rates we're seeing these days, which reflects in part the prevalence of the popularity of the preliminary guidance. I think, though, to the extent these rates are a little lower than the overall rate, I think it's, again, sort of a mindset of risk-taking on the part of the patent owner, because even the revised motion to amend isn't their last chance to amend the claims. There's the new ex parte re-exam off-ramp was introduced, I believe, 2018 or 2019, where patent owners can now, after a final written decision, but before the issuance of a trial certificate, file an ex parte re-exam to start entering amendments, this time without the pesky petitioners raising unpatentability grounds at them. So, when a patent owner gets unfavorable guidance and decides to bulldoze ahead anyway, we've actually seen some kind of odd results. I think it's just a product of the small sample size. They've actually gotten at least one claim entered 50% of the time, 10% of the time for all claims entered, which that 10% is a little more in line with what we expect. That 50%, small sample size, likely random chance. In one of those cases, the patent owner was actually able to turn around a product by process claim construction issue. The board didn't want to give the process limitations and a product claim patentable weight, but the patent owner ultimately persuaded the board that the process limitations conveyed structure. So they created structural limitations and were successful on that front. In one of the mixed decisions, it was essentially a revised motion to amend. It just dropped the claims that were found did not get favorable guidance from the preliminary guidance. And this was treated as a reply instead of a revised motion to amend. So there's still a small sample size, still a lot of noise. And to the extent there's any sort of unusual results there, I think it's just early days. We need more data. We need to see what happens. So Alyssa, I think you talked a little bit about your experience dealing with a patent owner that got some unfavorable guidance, but then bulldozed ahead anyway, didn't file a revised motion to amend. How did you address that as a petitioner?
Well, so it was interesting in their case because they did file a revised motion to amend, but it only corrected one 112 issue, and it did not address the grounds that we had, the prior art. And as I mentioned, it failed to address other 112 issues. But so we prepared our, reply to it and addressed their comments that they put as to why they thought their claims were patentable over our grounds, despite the guidance, and tried to make sure our response to that was tailored, but still including all of the citations and references the board would need for finding the claims unpatentable, and then adding in what we needed to actually tailor a response to what their comments were.
So it wasn't just a matter of referring back to your original opposition with respect to the unpatentability grounds. It was also making sure the board had those issues in front of them.
Correct. Yeah, we did repeat a lot from, the original opposition, and then added in what we thought was necessary to address the specific patent owner's comments in their revised motion.
Mhm. All right, so we've covered what happens with motions to amend, and the next thing we're going to cover is after the motion to amend. This is things like appellate review, estoppel, intervening rights, all of that fun stuff that happens after the motion to amend is either granted or denied. So one of the first things to consider is, what are your standards of review pertaining to motions to amend if you are appealing a final written decision, or if you are the appellee in a case where the patent owner has filed a motion to amend. Ultimately, what we really have just here is a table that gives you some really straightforward, what's it a question of and what's the standard of review. Probably the big one to keep in mind here is written description and new matter. That's reviewed for substantial evidence. And the other one to keep in mind is claim construction, which is reviewed de novo. So, usually if you're the patent owner, you'll see a lot of these are reviewed for substantial evidence, anticipation, the underlying factual findings for obviousness, written description. If you're a patent owner, more often than not, you want to try to make that an issue of claim construction if you can. Or something that is a little less deferential than substantial evidence review. You also have Administrative Procedure Act review of final written decisions, and those cover things like notice to each party of the matters of fact and law asserted against them, as well as an opportunity to respond, submit rebuttal evidence, submit arguments, and then as well as making sure the burdens of proof are properly allocated, statutory and regulatory requirements on the patent owner, patentability on the petitioner. So after the time for appeals expired, either because an appeal has gone all the way through or a patent owner has declined to appeal, or appeal takes place for whatever other reason, you have a trial certificate, and this is a separate document issued by the Patent Office that states what claims have been added, what claims have been canceled, what claims have been amended and how. Worth noting is that the patent owner cannot actually assert new or amended claims until the trial certificate actually issues. And that can take a while. I think I had one appeal where we had dismissed the appeal, but the trial certificate took close to a year to issue from the Patent Office. There's no set deadline for it. So that can slow things down a little bit, and is something to keep in mind if you are attempting to assert amended claims in litigation. So turning to intervening rights, intervening rights are probably the number one reason I don't usually recommend filing motions to amend as a patent owner. Absolute intervening rights means for any amended claim, you have no past damages available. Equitable intervening rights essentially means that if there is substantial preparation for something that would have been infringed by the new or amended claim, future damages on that may not be available just as a matter of equity. Alyssa, do you see patent owners arguing sort of continuity of claim language, or that the claims are substantially the same even if they're amended, so that the patent owner is trying to protect themselves from intervening rights?
I haven't seen it in any of my cases, but that doesn't necessarily mean that they're not trying to do that. I think, an issue that they have is, these amended claims are contingent on the original claims being unpatentable. So there is that issue that if they're saying they're the same, that, why are substantially the same, why are these new ones now patentable?
Yeah, I have seen it once or twice where the patent owner says we're just clarifying what it perceived to be a erroneous broadest reasonable interpretation in the claims back during the broadest reasonable interpretation days, or that it's just a clarifying amendment, but also that clarifying amendment somehow distinguishes the claims over the prior art in a way that the original claim didn't. It's a little mystifying, but you do see it happen, and you can kind of see the reasoning behind it. I haven't seen it work though. I was just curious, your experience on that as well, and yeah. All right. So next we have petitioner estoppel. So if there is a claim in a patent that is subject to a final written decision, the petitioner is stopped from raising either in litigation, and what we've got on the screen is the litigation version, or in a subsequent IPR or other post-grant proceeding, any ground that was actually raised or reasonably could have been raised. One of the big questions, though, and this harkens back to the trial certificate, is a new or amended claim added by a motion to amend in the patent as of the final written decision, given that those new or amended claims don't get added until the trial certificate. And I haven't seen case law addressing this, not from the Federal Circuit. I think we're going to get a decision out of the Pulse Court in the Southern District of California a couple slides back on that issue. But Alyssa, what experience do you have with petitioner estoppel with respect to amended claims? Have you seen it come up in your practice representing petitioners?
So I will say I haven't seen any decisions, like you said, saying, what the final outcome is. But I think that as the petitioner, you want to, again, be very cognizant when you're opposing these motions to amend, and make sure if you need to do a prior art search that you're getting it done early enough, because the timeline that you have to respond to that motion to amend is so different than responding to ones in trial or when you're preparing your initial petition, that if there was potential estoppel, you want to make sure that you've at least put the best case that you have had forward.
Yeah, especially because you can also raise those 101 defenses, those 112 defenses in district court. So if you're a litigant, you definitely those could fall under the reasonably could have raised if the Federal Circuit should find that the amended claims are considered in the patent for purposes of applying estoppel as of the final written decision. It'll be an interesting issue. With almost 10 years of the AIA now, we haven't had this issue come up, and I think it's surprising, but in some respects not surprising, because you have to have a pretty unusual confluence of events, right? You have to have a successful motion to amend. You have to have, the litigation is still going afterwards. There's not a settlement, or intervening rights doesn't wipe out the entire damages window, and it's still a live enough issue for the parties to be litigating all the way to the Federal Circuit. So it'll be interesting. I think we'll get a decision eventually if this Pulse Electronics case keeps going, but just haven't seen it yet. And some guidance from the Federal Circuit would be beneficial on that.
Yeah, and as being on the petitioner side, I think I agree with you with the trial certificate coming out later, that there should not be the estoppel there, but we'll see with what the courts say.
Yeah. And finally, this is the lesser spotted patent owner estoppel. This is a regulatory estoppel. So the patent owner can't do anything inconsistent with the final written decision, including getting a claim that is not patentably distinct from a finally refused or canceled claim. What all of this means is, at least in the patent office, if you lose a motion to amend, you can't get patentably indistinct claims versus reissue, re-exam, or continuation practice. You've heard me allude a couple times to the so-called reissue or re-examination off-ramp. That's a newer program installed by the patent office to give patentees the opportunity, after an unfavorable final written decision, to file an ex parte re-exam or a reissue. to try to get narrower claims, as opposed to just appealing directly to the federal circuit. Instead, they can go back into prosecution essentially and narrow their claims that way. But again, an unfavorable final written decision, unfavorable motion to amend in the final written decision, you're not getting claims like those claims or those exact claims either. So finally, we've got some practice tips for both patent owners and petitioners. I'll kick off the patent owner section and then turn it over to Alyssa for the petitioner section. But the number one thing you need to keep in mind as counsel for a patent owner is it really worth filing a motion to amend? It's very difficult to win. It is very expensive for your client. There are intervening rights. And are you, maybe you're better off, in fact, probably you're better off from litigating the claims as is. And if you lose, then go for reissue, then go for reexamination. And in fact, I generally prefer the reexamination route, simply because you don't get a quote unquote new patent for purposes of applying the 1-year time bar for related litigations. It's considered the same patent. So, it's very often just not worth it as a patent owner. If you are going to file a motion to amend, as Alyssa mentioned, make sure your attorneys are handling the motion to amend are clear of any prosecution bars. Make sure that you have proofread your claims carefully, right? There are no examiner amendments here. There are no 312 amendments here. If you put a "the" where an "a" should be, you're not getting that fixed. It's going to be held indefinite. So, make sure you are carefully reading your claims. For the new matter issue, again, if you're losing a new matter issue with the PTAB, you're probably going to lose it on appeal. Substantial evidence is a tall mountain to climb for a patent owner or anyone trying to overturn a substantial evidence issue. And finally, as Alyssa mentioned, carefully review the board's preliminary guidance in filing a revised motion to amend. You're certainly welcome to swing for the fences with your opening motion to amend. If you're in a sufficiently desperate situation that you're filing a motion to amend, you may as well go big or go home. But when you get that guidance, you need to heed it.
Yeah, so I think I've said this several times today for the first tip. You need to determine, very quickly whether a new search will need to be conducted. With the tight timelines that are involved with these motions to amend, you can't get the same types of extensions that you may get on a patent owner response or reply. There's just not time in the schedule to allow for it. So you need to be on top of making sure that you see your deadlines and you're on top of when you need to have prior art. Another thing is carefully consider the potential deficiencies for the statutory requirements. Did the patent owner try and add new matter? Did they, or just fail to show where support was? That can be, really helpful because they have the burden of showing that they've met those requirements. Whereas whenever you get to your grounds, you have the burden of showing that the claims are unpatentable. And then in addition, consider whether there's 101 or 112 issues that you want to raise. Is there things in the district court that you're raising under 101 and 112 that you can also raise in front of the PTAB now because they didn't address those in their amendment? Or maybe by their amendment, they've raised new things that are now 101 or 112 issues. And then finally, you have less pages to address this opposition than you did, your original petition. So you want to make sure you prioritize the best grounds and the best challenges to meet the page limits. So for example, if you think there's like this little tiny thing that might be new matter, but you don't think it's your best argument and you really think the prior art is great, then maybe you do want to prioritize the prior art and having more explanation in there instead of raising the new matter argument. In addition, if you're basically using grounds that you used in the petition and you're just adding a new explanation for the new limitations added or a new reference for the new limitations added, you don't need to repeat all of the grounds that you wrote for the original part of the claims. You just need to address the new amended portions of the claims. And so that can help you meet the page limits.
All right, so that covers all of our slides today. At this time, I think we'd love to get questions and answer any questions you have about motion to amend practice.
If you have any questions, feel free to unmute yourself to ask. It was so comprehensive. No questions.
Well,
That's
thank you, everyone.
We're thorough.
Yeah, thank you for joining. And this was fun. I hope you enjoyed the presentation.
Awesome. Thanks, everyone.